the Minister was talking about giving the ICO more powers. The question is how we use the powers we've got, how we're going to use the powers that we're going to get. And I want to share with you the conclusions that we drew from an exercise we've been conducting over the past 12 months or so, trying to work towards a vision of what a modern regulator should be like. We talk about towards a 2020 vision for the Information Commissioner's Office here in the UK. And we conducted a consultation. I shamelessly stole a leaf out of the EDPS book, whose consultation on their strategy was so well conducted. And we came up with the idea of looking ahead, staying ahead. Because the only thing we know is that we have to change. Because technology is changing, business is changing, legislation is changing. We don't know what the change is going to be, but we know it affects us and we have to be ready. And part of the exercise was to ready the organisation for the tsunami of change which is coming at us over the next couple of years. And we analysed, again, thinking about Mr. Rumsfeld, the American Defence Secretary. We looked at the known knowns, the known unknowns, and the unknown unknowns. And it makes an interesting picture. What are the known knowns? There's more to do. We are busier than ever. We're handling more cases. We're receiving more inquiries. We're receiving more calls to our helpline. We are in the growth business. Information rights is the priority of citizens, consumers, businesses, politicians. We are absolutely centre stage. The other known is that we've got less resource to do more stuff. And we're told that better for less is the name of the game, and okay, we're up for that, and we are in the efficiency and effectiveness business. But those are the two big known knowns. More to do, have to be more efficient, because nobody has got a whole pile of money to throw in our direction. Then, what about the known unknowns? Well, we heard about the main one this morning, the EU regulation. What's it going to say? When's it coming into force? Very encouraging to hear that we're driving for completion in 2015, and then, of course, there's some run-in period until the legislation goes live. But it's very difficult to plan when you're dealing with a text which starts off from the Commission in this very prescriptive dirigiste way. It's very difficult to plan how you're going to organise a data protection authority if you don't know precisely how the obligations are going to land up at the end of the legislative process. And then there are the unknown unknowns, what Harold Macmillan used to call events, dear boy. The impact of the Google decision from the Court of Justice of the European Union could be profound for a data protection authority with Google UK apparently dealing with, as I said this morning, 40,000 requests from individual citizens saying, take that down, I don't like that search. Unless Google says, fine, okay, we'll do that, and I don't think they will, then there's an awful lot of additional work coming our way, which none of us predicted a few weeks ago. So, I think I've been asked to speak here today because in the conclusion of our strategy work, one of the ideas we put forward was that we were going to be tackling our complaints handling, our case handling in a rather different way, emphasising the learning from casework. And when Peter Hustings said this morning, data protection authorities have to be more strategic, it's not going to be possible to deal with a case-numbered approach. How right he was. Let me share some figures with you. In the UK, last year, the ICO dealt with 40,000 inquiries, approximately 14,000 data protection cases, approximately 6,000 individual complaints investigations. Now, I've got the resources to do this. I talked about £16 million to spend on data protection. Quite what I do when the new regulation comes in, I don't know, but we'll sort that out. But I've got the resources. I'm leading an organisation with 388 staff. Now, okay, about a fifth of those will be involved in the freedom of information side of the business, which isn't really our concern today. But nevertheless, we are big. But we have to be big because the caseload that we're dealing with is massive and it can only grow. But if I tell you that of those 6,000 data protection complaints which we investigate the full 9 yards, only 35% of those resulted in a compliance unlikely ruling. We've come to the conclusion that many people come to the ICO as a first resort rather than a last resort. We're very often dealing with concerns that are put to us or complaints that are about a bad relationship with the data controller, where the data controller hasn't actually been contacted. And very often it's simply a breakdown in a relationship, a huge fight between the citizen and an organisation or a company, of which data protection is either only a part or is one of the weapons in the fight.